With that, we will call the meeting of the Cannabis Compliance Board to order. Our first order of business is our roll call to make sure we have a quorum.
Great. Member Merritt. Member Merritt.
Present. I'm here.
Great. Member Durrett.
Here.
Member Young.
Here.
And Chairman Douglas.
Here. And we note for the record, Member Nylander is not present today, but we do have a quorum. If we can have our public comment as our first order of business.
Is there anyone in Las Vegas wishing to provide public comment today? If so, please come up to the podium. State your name for the record. Chair, I do not see any.
We have no public comment and in Las Vegas this morning, and we note for the record that there is a delay up in Carson City today because it is a snow day up north. So those of us in Las Vegas feel happy. With that, note that under item 4, premium products is going to hold today and be pushed to our next agenda, which will be in March. So if there was anyone here for that, that matter is off today. Coming back to our primary agenda, item 2 is the meeting minutes of our last meeting of January 25th, 2022. For our board members, if they've reviewed that item, if we can have a motion or any corrections.
I move to approve the meeting minutes from the January 25th, 2022 meeting.
It's been moved. Do we have a second?
This is Member
This is
Young. I
Member
second
Merritt, second.
We have a dual competing second. And with that, any discussion or corrections? Hearing none, all in favor, please say aye.
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 Aye. It's unanimous. That motion's carried. We come now to item number 3, consent agenda.
Excuse me. This is Christy, the court reporter. Can I please have everyone state their appearances before they speak? I'm in Carson City and I don't know any voices. I've never done this board before, so I'm having a hard time configuring out who's speaking.
Thank you. That will be noted. This is Chair Douglas for the record. Item number 3, consent agenda. Item A is complaints. We have 2 proposed complaints in A and B. For the record, if we can have that information.
Thank you, Chair. And this is Tyler Cannabis for the record. Item 3A on the agenda concerns 2 complaints for disciplinary action pursuant to NRS 678A510. The Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. As we did at our last meeting, I'll be requesting board approval to proceed with each of these 2 disciplinary actions. If approved, I will then authorize service of complaints. Once the board approves proceeding with disciplinary action, service will proceed within a reasonable time. Once they are out for service, we will post them online. As to respondent A, the complaint will allege violations of NCCR 4. And as to respondent B, the complaint will allege violations of 678B and NCCR 4 and 7. Chair, back to you.
We note for the record that these are presented to the board in a blind state. We have not seen them or reviewed. They have been processed by the staff of the Cannabis Compliance, that they've met the requirements pursuant to Nevada revised statutes. Our obligation is to, if any, to allow these to go forward. So with that, can we have a motion as to items A and B?
Member Durrett, for the record, I move to approve items A and B under consent agenda relating to the complaints issued against respondent A and B.
Do we have a second, please? It's Chair Douglas for the record.
This is Member Young. I'll second that.
We have a motion. We have a second. Any discussion? All in favor of the approval of the complaints, please say aye.
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 It's consented to unanimously. That moves us to item number 4. Again, Chair Douglas, for the record, request for transfers of interest as indicated, item A, premium products is moved to our March agenda. That takes us to item B, healthcare operation for patients enterprises. So we can have our report, please.
Good morning. Chair Douglas, Member Merritt, Member Durrett, and Member Young. For the record, I am David Staley, Chief of Investigations for the CCB. I'm here to present agenda item number 4, which consists of 4 transfer of interest or TOI applications. Item B is a TOI application for healthcare options for patients enterprises LLC or HOPE. TOI 22001 requests approval for waivers of NCCR 5.110 pursuant to NCCR 5.112 and 5.125. HOPE also appeared at the January 2022 board meeting, but the requested waivers were not included in the January TOI. The 2 NCCR 5.110 waivers are included in this agenda to rectify their absence in the January agenda. Staff identified no areas of concern with this application. Staff suggests that if HOPE's waiver applications are approved, that the approval be conditioned such that HOPE's waivers pursuant to NCCR 5.112 and 5.125 be limited to expire on such agenda as HOPE's next TOI application is heard. I am available for any questions, and my understanding is that Brianna Martinez is present to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Good morning.
Good morning, Brianna Martinez for the record on behalf of HOPE. Good morning, board members. We agree with Mr. Staley, and we would ask for the board to please approve the waivers.
Chair Douglas, for the record, any questions by any board members of the applicant or our attorneys and investigators? Hearing no questions from board members of the applicant, staff, if we can have a motion and if parties feel appropriate, the waiver of the 5.110 requirements. That was Chair Douglas for the record.
Member Durrett, for the record, I move to approve the waiver of NCCR 5.110 pursuant to NCCR 5.112 and NCCR 5.125 upon the condition that the waivers be limited to expire on such time as the licensee's next TOI request is submitted.
Do we have a second?
This is Member Merritt. I second.
It's been moved and second for the record. Chair Douglas, do we have any additional discussion? Hearing none, all in favor, please say aye.
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 Aye. Matter carries unanimously. Thank you.
Have a good day.
Chair Douglas, for the record, moving to item number C, Jushi Holding Inc., New Leaf Inc., New Leaf Clark Dispensary, and New Leaf Inclined Dispensary, New Leaf Reno Production LLC, New Leaf COV, dispensary licenses as set forth in our agenda. We can have a report, please.
Thank you, Chair Douglas. This is David Staley for the record. Item C is a TOI application for New Leaf Inc. or New Leaf and Jushi Holdings Inc. or Jushi. TOIs number 21014 and 2100027 request approval for various New Leaf entities to complete internal restructuring prior to a planned acquisition by Jushi. Jushi has also requested approval for waivers of NCCR 5110 pursuant to NCCR 5.112 and 5.125. In addition to the TOI applications, this item doubles as the investigation into Jushi's suitability to receive a potential consumption lounge license. Jushi qualified for this review by establishing the required revolving account with the CCB and requesting such review. Staff's review that Jushi is suitable to file an application for a consumption lounge license. Consumption lounge licensure cannot be finalized until Jushi has completed all required submissions and location inspections, as will be detailed in the yet to be finalized consumption lounge regulations. Staff identified no areas of concern with this application. Staff suggests that if Jushi's waiver applications are approved, that the approval be conditioned such that Jushi's waiver pursuant to NCCR 5112 and 5.125 will be limited to expire on such agenda as Jushi's next TOI application is heard. I am available for any questions, and my understanding is that Melissa Waite, Jeff Donato, Sean Luce, and Harris Shane are present to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. And for the record, just to note that this is New Leaf and the new NU LEAF, because we have another item on agenda later that's new NEW Leaf.
That's
So,
correct.
With that, if we can have our parties at the microphone identify themselves and their comments.
Good morning, Mr. Chair, members of the board. Jeff Donato here with Argentum on behalf of the New Leaf entities. With me today is Mr. Sean Luce, which is the COO. And joining us today, Melissa Waite should have been here, I believe. Maybe she's stuck in traffic, not sure. But with that being said, we are here today, just like Chief Staley outlined, requesting the approvals of the transfers of interest of the New Leaf entities, which will ultimately go into the Jushi entity. And with that, we're here to answer any questions you may have.
Thank you. Questions by our board members?
Member Drat, I have a question. So does Melissa represent Jushi?
Correct.
Oh, okay.
And I believe there is a gentleman on Zoom that represents Juicy or is with Juicy.
Hi, Harris Shane here, Senior Vice President of Legal Affairs.
What is the timeline for the acquisition?
My understanding is that once we have all local jurisdiction approvals, then that acquisition will take place. We're waiting for today's approval from the CCB, and then we'll be working with the local jurisdictions to get those approvals. Once that happens, then the acquisitions will take place.
Other questions by board members? Hearing no additional questioning. This is a merger, correct?
Is acquisition of the New Leaf entities, correct? So the end result would be Jushi, the Jushi entity.
All right, thank you. Having said that, anyone else have any other board members have questions or comments?
I have another question. What's the plan? And I guess Jushi would have to speak to this for the local Nevada staff. Is the plan to keep them all in place? Hopefully add more?
Hi, so that is the intention. You know, we chose to do a merger because it keeps the existing apparatus in place. You know, obviously we have to go in there and sort of do our diligence and kind of do a holistic review, but the intent is to keep the business running with minimal changes overnight based on the closing.
How is that Tahoe dealing with the request for a change? I just imagine they're probably very careful about everything that happens there.
The New Leaf Incline Dispensary?
Yeah.
Sean, do you want to?
Yes, the Incline's not the jurisdiction, right? Is it Washoe
It's
County?
not,
Okay.
Washoe County.
Okay.
So, yeah,
So it's just
yeah.
Washoe.
Yeah.
so.
Yeah, it hasn't, they haven't raised any issues or questions yet. I don't really expect them to. And to answer your previous question, Rihanna, I will still be involved too,
That was
going forward.
my next
Yeah,
question.
Yeah.
Yeah.
So
That
in
was my
addition to the management team, myself, I'll be there.
Okay, that was my next question, and one that I have for a lot of the licensees in these changes is who's the boots on the ground in control, because I've seen a pattern of the ones where we have no management living in Nevada. Those seem to struggle more because you don't have the C-level, their eyes on the establishment. Thank you.
Any other board member wish to weigh in? If not, if we can have a motion, if you need clarification.
Motion, motion, okay. I move to approve for the transfer of interest under agenda item 4B on the condition that the waivers being granted under NCCR 5.110% to 5.112 and 5.125 expire on such time as the next TOI application is submitted.
Do you also, Chair Douglas, for the record, do you all also wish to indicate that we are also approving pre-approved to at least submit for the consumption?
Okay. Yeah. Okay. The board would, that motion would also include the board's approval that
As a
it
suitability.
appears the suitability for the consumption lounge at this time appears to be all in order, but with the understanding that would have to come back to the board for final approval. That makes sense? Okay.
And Chair Douglas noting for the record, this is not approving the consumption lounge at this point, just the suitability portion. With that, can we have a second, please?
This is Member Young. I'll second that.
It's been moved and seconded. Any additional discussion or questions? Hearing none, all in favor, please say aye.
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 Carries unanimously. Thank you.
Appreciate that. I'd like to say, thank Chief Staley and all his staff for the hard work on the transfer of interest applications.
Thank you. And we note that, yeah, the applications get more intricate as we go forward. With that, we pick up item D, which is Juicy Holding Inc. and SF-D Inc. Good morning.
Good morning.
Thank you. Thank you, Chair Douglas. For the record, David Staley, Chief Investigations. Item D is a TOI application for SFD Inc. or SFD and Jushi Holdings, Jushi. TOI number 2100014 requests approval for SFD to complete internal restructuring prior to being acquired by Jushi. Jushi also has requested approval for waivers of 5110 in connection with this TOI, but I don't think we need to vote on that because it's already been approved in the prior item. Staff identified no areas of concern with this application. I'm available for any questions, and my understanding is that Melissa Waite, Alicia Ashcraft, Barry Fieldman, and Harris Shane are present to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Identification and representations for the record.
Good morning, Chair Douglas, members of the board. My name is Melissa Waite. I'm here this morning representing the applicant and Jushi Holdings, the parent company. Apologies, I wasn't here for the prior item, but I understand you've already met Harris Shane, the Senior Vice President of Legal Affairs. We're here to answer any questions, and of course, would like to thank Chief Staley and his staff, Rachel Branner, for their assistance during the investigation.
Good morning, Justice Douglas, Director Klimas, and members of the board. Alicia Ashcraft of the law firm of Armstrong Teasdale on behalf of the seller, SF-D Inc., and happy to answer any questions on behalf of the seller in this matter.
Thank you. Questions, comments by the board as to this?
Could you kind of just do a little overview of it's just everything's just being transferred into a different LLC, is that right? And then
So actually, I believe it was on the December agenda. Chief Staley can correct me if I'm wrong. Gravitas Nevada LTD
I remember all that.
Yeah,
Just
did the
name.
reorganization
Uh-huh.
and the assets of the dispensary and the retail store were put into and approved to be transferred to SFD at that time. And so Jushi is now acquiring that entity, SF-D Inc., in this transfer of interest. So it will now become a subsidiary of their parent company structure.
Yeah, so they already purchased it, but now it's just being transferred into a subsidiary of their company.
Jushi has not purchased it yet. So they're going to be acquiring the stock of the entity that currently owns the license.
Okay, thanks.
And Chair Douglas noting for the record, this is a medical and adult use cannabis dispensary located in Las Vegas, Nevada.
Correct.
Right, if there's no other questions by the board, motion, please.
Mr. Staley, would you like waiver or the condition, same condition on this one or no? Are we doing a condition on this?
No, Member Durrett, I believe that the approval for the prior item will cover Jushi going forward.
Okay, so I move to approve agenda item 4D.
Can we have a second, please?
This
Member
is
Young,
Member
I'll
Merritt.
second that.
We have dueling seconds, so we'll accept both. With that, all in favor, please say aye.
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 Motion carries unanimously. Thank you very much. That brings us to item number 4E, Good Chemistry Nevada LLC, TO transfer of interest request.
Thank you, Chair Douglas. For the record, David Staley, Chief of Investigations. Item E is a TOI application for Good Chemistry Nevada LLC or Good Chemistry. TOI number 18077 was filed in 2018 for the removal and replacement of various Good Chemistry officers. While no changes in ownership were included, the policy of the Nevada Department of Taxation during 2018 was to handle changes to officers through the TOI application process. As a result, staff is requesting withdrawal of TOI 18077 to clean up our records. However, during the investigation, staff did identify areas of concern with this application regarding Good Chemistry's failure to file and pay various tax returns. I'm available for any questions, and my understanding is that Polly Bayham, Joseph Sandoval Jr., and Jeff Donato are present to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Please.
Good morning, Mr. Chair, members of the board. Jeff Donato here with Argentum on behalf of Good Chemistry. Joining me today by Zoom in Denver is Ms. Bayham and Mr. Sandoval. We should be able to.
Yes.
Just for the
Good
record.
morning.
Good morning.
And with that, we're here to answer any questions that you may have regarding this application to withdraw a TOI application. It was essentially a letter that was submitted back in 2018 for a request to update the owners and officers of Good Chemistry. And just like Chief Staley has indicated, it was treated as a transfer of interest, although there was no ownership change. So therefore, we're asking for this to be withdrawn so that we can clean up all the records with regards to the officers and board members.
The additional item that Chief Staley indicated in terms of taxes, noting what we have is late filings, but my understanding is all taxes are present up to date.
Correct. So those are all zero returns. There was no money or funds due to the state. It was all zero returns that were not filed in a timely manner for those zero returns.
With that notation, and I think there was a comment that you would change the individuals who were taking care of those items.
Correct. So Good Chemistry has moved away from that company and now using another company for their tax returns.
Thank you. With that, I'll make a motion for the withdrawal of the prior TOI applications that were submitted. If requested withdrawal. If we can have a second.
Member Durrett, I second.
Any discussion? All in favor, please say aye.
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 Motion carries unanimously.
Thank you.
Very much.
Thank you.
Thank you.
That moves us to item V. Request for consideration of approval of management services agreement, New Leaf Cultivation Center, and Cannabis Services Reno. We have parties here.
Thank you, Chair Douglas. For the record, this is David Staley, Chief of Investigations. Item number 5 is a February 8th, 2022 Management Services Agreement or Management Agreement between a New Leaf, spelled N-E-W, Cultivation Center LLC and a New Leaf Production Center LLC and Canvas Services Reno SPPC LLC or Canvas A new leaf is currently in receivership, and the management agreement provides for Cannabis to supervise and manage the day-to-day cultivation and production operations at a new leaf's facilities. Cannabis will receive a monthly fee of $13,000 plus 20% of net profits. Once the profit share amount reaches $20,000 in any month, the $13,000 fee ceases. An area of concern was identified because one of the members of Cannabis, Ranson Shepherd, is also a 21.5% owner of Las Vegas Wellness and Compassion LLC, or LV Wellness, which holds cannabis cultivation and production licenses. LV Wellness recently settled 2 complaints before the board in June of 2021, and further compliance issues are currently under review by the CCB's audit division. CCB staff have reviewed the agreement and found it appropriate. CCB staff recommends that the board consider approval of the relationship between A New Leaf and Cannabis rather than approval of the agreements themselves. I'm available for any questions, and my understanding is that Ranson Shepherd, Joseph Davidson, John Savage, and Dotan Melek are present to make a brief presentation to the board and address any questions you may have as well. With that, Chair Douglas, I will turn this item back to you.
Thank you. We can have representations for the record.
Good morning, Chair Douglas, members of the board. John Savage on behalf of Dotan Melek, the receiver for New Leaf entities, common spelling. Mr. Melek is also appearing today remotely by video. We are here to answer any questions the board may have, as is Joseph Davidson from Cannabis. Mr. Ranson Shepherd is not available today. And Ed Humphrey, counsel for the host parties, one of the ownership groups for the New Leaf entities, is also present.
Yes, just for the record, board members, it's Ed Humphrey for Alexander Hose and his related entities, owner and interested party in the receivership. We have fully vetted the management agreement with the other interested parties in the receivership, and my clients are satisfied with moving forward with this group, and we're very impressed with the first couple of days that they had visited the site.
Parties understand the area of concern that Cannabis et al. Has with Mr. Ransom Shepherd in terms of dealings.
Yes, Your Honor, Chair. We did, this is the first that we heard of it. However, we are willing to work with the board in any manner or desire.
And for the record, Chair Douglas, I'm going to move for approval of the relationship. I said approving as to form, basically, of the management services agreement, not actually to the content. And with that, we note that there is a concern which we will be monitoring. If it comes to more than a concern, put back on calendar, just to let you know, but the motion is for approval today. With that, do we have a
This is Member Young.
please?
This is Member Young. I'll second that.
Thank you. We have a motion. We have a second. Any additional discussion or questions by board members?
Is it possible or advisable, whatever the chair would prefer, to maybe bring back Mr. Shepherd another date to question him about?
At this point, based on what we received from our staff, they've resolved 2 issues. They have one that's under investigation. That raises a red flag. We would ask our folks to back on. So I think we are covered at this point. So we have a motion. We have a second. On the vote, all in favor, please say aye.
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 Carries unanimously. Thank you. Good luck. I hope the receivership works out for everyone.
Thank you. Thank you.
We have a request for consideration of approval of court-appointed receiver application for cannabis establishment agent registration card for cannabis receiver. That's item number 6. And we have one item.
Good morning. For the record, I am Senior Deputy Attorney General Ashley Balducci, Chair and members of the board. Agenda item 6 involves a request for the board's approval of the court-appointed receiver Larry Birch's application for agent card for a cannabis receiver over a cannabis cultivation facility. After I provide a brief summary, counsel for the court-appointed receiver, Candace Carline, who is present via Zoom, and the court-appointed receiver and applicant, Larry Birch, along with his employee, Mr. Clycamp, are both present in person for questioning by the board. Mr. Birch has applied to the CCB for a cannabis establishment agent card for a cannabis receiver, which, if approved by the board, would place him as a cannabis receiver over Helios NV LLC. In his application, Mr. Birch attached his curriculum vitae that identified the cases in which he has acted as a court-appointed receiver, which also includes experience as a special master in a bankruptcy court proceeding involving an ownership dispute of a state-licensed cannabis sales facility. By way of background, Helios operates a state-licensed medical and adult use cultivation facility in Reno, Nevada. According to the operating agreement for Arjun LLC, Arjun owns Helios and several individuals own Arjun. Irene Howard, one of the owners of Arjun, filed a derivative lawsuit in Second Judicial District Court against Hydrovise International, Inc., a management company, and Wes Pileski, the owner of Hydrovise, and one of the individuals who also has ownership in Arjun, alleging various claims involving the management and operations of Helios. After several applications by Ms. Howard, the arbitrator granted an order appointing Mr. Birch over Origin and Helios that the court later confirmed. The CCB also has a pending disciplinary action against Helios that is presently stayed pending the CCB's action on Mr. Birch's application. Should the CCB approve Mr. Birch's application for a cannabis receiver agent card, placing him over Helios, the order should include language that Mr. Birch is to take immediate possession and control of Helios and manage its operations in the best interest of the company and in compliance with Nevada law. Mr. Birch would become the designated point of contact for Helios pursuant to NCCR 2.050. Mr. Birch would also be responsible to responding to any and all inquiries and investigation requests from the CCB and its staff. Mr. Birch will be subject to all the responsibilities and requirements of an agent cardholder under NRS Title 56 and the Nevada Cannabis Compliance Regulations, including but not limited to any disciplinary provisions. Mr. Birch must be independent and may not be represented by counsel for Helios and or counsel for any of the owners for Arjun. Mr. Birch may retain independent counsel to represent himself, and he has already done so. Mr. Birch should further be ordered to provide the CCB with a report of his initial activities with Helios no later than Tuesday, March 15th, 2022, and then provide reports to the CCB thereafter on a monthly basis on the 15th day of each month or the first business day thereafter. Mr. Birch should remain in place until the CCB has approved his removal, if approved. Helios or any of the individual owners of Arjun may apply to the CCB to remove Mr. Birch at any time, but the CCB must approve removal by a majority vote. Helios is to be responsible for payment of Mr. Birch's fees and costs for the execution of his duties. With that, I will turn it over to Ms. Carline, Mr. Birch, and Mr. Clycamp for any questions the board may have. The board may then vote on Mr. Birch's application for an agent card as a cannabis receiver, placing him as the cannabis receiver over Helios, with any of the suggested recommendations stated to be included in the board's order. After the meeting, an order will be prepared outlining the facts and confirming the board's decision in writing. Thank you.
If we can have representations and identifications of the parties here to speak.
My name is Larry Birch.
Mr.
My name is Richard Clycamp.
Good morning, Chair Douglas. This is Candace Carline, counsel for Mr. Birch. I appreciate the opportunity to appear via video. I have known Mr. Birch for decades. He served as a U.S. bankruptcy trustee for more than 20 years. He has served as a court-appointed receiver in multiple actions, and he is very well suited to address the issues which are raised in the disciplinary action, which thankfully has been stayed pending Mr. Birch's appointment. Mr. Birch would be happy to answer any questions regarding his qualifications. We would ask that the decision of Chief Judge Simmons to appoint Mr. Birch as receiver over these companies be confirmed by this board. Thank you.
Mr. Birch, I guess the underlying question is if you would give us an outline of why this body should approve you. You have a very extensive resume in terms of being a special receiver, so to speak, as to bankruptcy actions, Chapter 7s, 11s, 7 operating, special master, liquidating trustee, special assignment bankruptcy court, receiver for the state courts, receiver family courts, receiver consultation, special master federal district, special master state courts, special master family courts, trustee federal district, bankruptcy examinations, bankruptcy distributing agent, consulting, an expert witness, trustee consultant, and forensic examinations. As you're venturing into new ground, how would you deal with cannabis, sir?
I have been associated with a couple cannabis things in town, CW Nevada, and also the Desert Air at 420 Sahara. So I'm not unfamiliar with what's going on. And I see it as a challenge, and I love challenges. So we'll get it solved.
Questions by members of the board?
Member Durrett, for the record, so what role did you have in the CW receivership?
I participated quite a bit in the beginning of it until they appointed another receiver, but I brought myself up to date in case I was appointed.
And what about Desert Air? Were you appointed as a receiver in that case?
In Desert Air, I was appointed because there was a conflict between the two owners. And I was appointed, and then they finally settled. So we had that, but they didn't like me snooping around. So I think that was the reason they settled.
It may be a good thing that you were snooping around. Other board members wish to inquire?
Thank you, Chair. If I may make an appearance, my name is Ed Humphrey. I represent the landlord for Helios 800 Stillwell Partners LLC. And one of the things that was particularly interesting or about this receivership, as with any of them have their own quirks, but this one started off in an arbitration. And so it's really been the arbitrator that's been issuing the orders, and the district court has been confirming those orders. However, parties like my client and other creditors of the entity of Helios are not parties to that arbitration, are not subject to the same arbitration agreements that are there. And we think that there's some issues that presents, particularly with notice on how everybody's going to get gathered into the same place. So as we move forward, I think it's crucial that there's a proper forum for this to take place. Whether or not that's inside of an arbitration, I'm not sure if that arbitrator has jurisdiction to make any rulings over my clients. And so the dual track of that, I think needs to be addressed.
Thank you. We have another party.
Justice Douglas, members of the board, thank you. I am Jeff Barr. I represent Irene Howard in the receivership action, in the arbitration action. For the board's edification, this was originally filed in the 2nd Judicial District in Washoe County. The orders of the arbitrator are subject to the board, and I understand that the court still has jurisdiction over every order of the arbitrator. So there is no issue with procedure or due process. Everything will be handled through the 2nd Judicial District.
Thank you. Note for the record that we do have various copies of arbitrators' decisions, and court sign off on that since it's under the jurisdiction of the 2nd Judicial District in Washoe County. We note that I noted that the arbitrator used the word that this board must, but the court was very good and said the court may. And we note that we've had appointments subject to this board finding suitability of Mr. Birch as receiver. I would make a motion of this. We have other comments or discussion that any board member wishes to make for approval of this receiver. At this time, noting the appointment does not become final until this board issues its order. With that motion for approval, do we have a second?
Member Durrett, I second.
Been moved and seconded. Any additional discussion? Hearing none, all in favor, say aye.
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 Carries unanimously. I would note concerns that were raised do need to be addressed either to the arbitrator or to the Second Judicial District Court. And please let us know also if there are concerns. With that, the motion is carried. And the process of getting cards and such is being taken care of.
This is
Chair
Ms.
Douglas, for the
Connolly.
record, David Staley, I don't know if agent cards have been applied for yet.
This is Ms.
Ashley
Connolly.
Balducci for the record, they have, and they also have their backgrounds done as well. They were just waiting for the board's approval to issue the cards.
Fantastic. Thank you very much. That gets us all squared up and on the same page.
Thank you.
That moves us to item number 7, petition filed pursuant to NRS 678A.4601 sub 1 sub D, White Pine County, Silver State Government Relations, on behalf of Silver Lion Farms petition to Cannabis Compliance Board to amend Nevada Cannabis Compliance Regulation 5. I know we've had some issues this morning.
Hello, everybody.
Chair, members of the board, good morning. This is L. Christopher Rath, Senior Deputy Attorney, to introduce the matter. And just to introduce the matter, agenda item 7A is a petition for amendment to a regulation filed pursuant to NRS 678A.460 subsection 1 and NCCR 4.145. White Pine County, through its county manager, filed the petition. It was also signed by a representative of Silverline Farms. The county is supporting Silverline Farms' attempt to obtain a cannabis cultivation license. The petition seeks the addition of a proposed NCCR 5.036 to the Nevada Cannabis Compliance Regulation number 5. The text of the new proposed NCCR 5.060 is set forth in the petition. The petition provides the petitioner's reasons for the requested addition of the new proposed regulation. The new proposed regulation essentially seeks to allow a board of county commissioners to request a new licensing round for non-statutorily restricted licenses such as cultivation or production facilities. As worded, with certain limited exceptions, it would require the CCB to open a new licensing round for such facilities on the request of a board of county commissioners. I understand representatives of White Pine County and Silverline Farms are here for any questions the board may have on this petition. I'll turn it back to the chair now to entertain any further comments.
On behalf of White Pine?
Definitely, thank you. Chair Douglas and members of the Cannabis Compliance Board, I am Will Adler. I'm here representing White Pine County. Slight maybe correction to some of the intro there. This is a petition from White Pine County, the county itself, petitioning the CCB. It is not, from Silverline Farms, actually. So also on the call, or hopefully on the Zoom, is Mike Wiebel. He is the county manager of White Pine County, and he can identify himself later or now as he sees fit. But I'm just going to sort of jump into this. And, as you have questions for me around cannabis and the regulations here, please do so. And about White Pine County itself, please direct them to Mr. Wiebel if you can. So, thank you in general for hearing this petition today. It is a long process that White Pine County has gone through to undergo these steps to sort of stimulate cannabis activity and economic diversification in their county. The county ordinance 500.23 introduced back in August was approved in October in White Pine County, declared that cannabis would be legal and cannabis as its whole would no longer have any moratoriums or restrictions in their county. This is after having months and months of discussions around this and sort of becoming aware of cannabis and what it means to have it in their county. And they went through it in a very thoughtful manner. They did have a couple meetings that stimulated the formal writing of a letter, January 12th of this year. That letter was submitted to the CCB formally to state, we have made this declaration, we have done this action in our county. How will we seek licensing, or how will we get economic activity around cannabis in this county, right? There is a difficulty to date where if you had a previous moratorium or restriction as a county specifically, especially under medical marijuana back in the day, you had to pick whether you were in or out. And those rural counties, most of the counties in the state, in fact, picked to be out of the marijuana program. There was almost no other chance in other stimulated times because the 2018 licensing round was a time where you had to have a cannabis license to stimulate new licensing or activities around it. Nobody applied to White Pine County because of the continual moratorium. Since then, the county commission has changed out, and a long process has developed here where they have developed a new opinion. Well, the new opinion isn't worth a lot if there isn't actually something to be done with it, right? This is a county of a very small population base. It has 9,000 residents or so, and it literally has a diversification eye for cannabis in their economy here, because it is a county driven by agricultural prospects and mining, and without other things to stimulate it, it does have a limited lane to be in. Cannabis can be one of those lanes, and having even 100 jobs in a county that size is a gigantic impact to that county, right? That is the reality of why this county has gone through this process and come to you this day to petition this issue, right? So after we did talk to Director Cannabis and we sent in the letter on January 12th, we had another follow-up meeting in February to ask where we could do this and how best it could be done. As the letter indicated, it has the same language as we've submitted in the petition here today, but the letter indicates essentially exactly what the county has stated. They want to see licensing, they want to see this economic activity, and the restriction is the lack of the ability to get licensing out of the CCB or have a licensing diversification around. Referencing sort of the law and going through it with them, we also did find a citing in NRS to date that says NRS 678B.220 that there is not even a licensing round needed, but there's a clause that there shall be a medical cultivation and shall be a medical production license, at least one, given to each county. Based on that precedent that we saw in the law, we simulated this writing of the regulatory request that says, okay, if there shall be at least one in each county, the intent is to not have this blocking out of cannabis activities in any county. So to stimulate a reasonable and limited window, White Pine County wrote it as such that they could petition the CCB directly through a letter from a county to stimulate licensing only in that county for only the limited licenses types that aren't restricted, right? Lounges are out, dispensaries are out because they're statutorily limited, and that is understood. But there's an idea that if a county has chosen that they need to have this activity, need to have the licensing available and have that economic activity in their county, there's no reason they shouldn't be allowed to start that in this county other than the quirk of regulation of law that we're in today that has said you had to join up way back when to have any of that activity today. We know that there's no ability to transfer licenses between counties or between jurisdictions. So that's not an opportunity where we could take one from Washoe, Clark, or any other county and move it to White Pine County, because that's a previous restriction in state law. So the stimulated activity, all this time and effort we spent in the meetings we've had with CCB brought us to this petition. We asked directly on the meeting in February, what is the mechanism we should do to stimulate a regulatory change? And the initial intent of the letter was hopefully to change it with the regulatory uptake we're doing today and NCCR 5. But, to have a more direct point on it and to put it in the proper format, we did submit it as a petition for you guys today. So hopefully you did take a chance to read it. It is pretty long and inclusive with their ideas and everything else, but that is the origin of why we've gotten here today. There truly isn't a good mechanism or any mechanism really to have this happen on its own. There does need to be some sort of change or stimulation to have this here. I don't think this language is perfect myself. It does have a lot of mandates. It is a very shall written and heavily based language here that we've submitted, but it does get to the point of how shall this county go forward and get this activity in the foreseeable future. I'm not saying this is perfect, but we are going through a regulatory change right now. So if not this language, maybe something like it or something to this effort could be done for this county, because they have gone through a big effort and they've spent a lot of time on this and gone through all the steps they could formally to be here today. So, please go through it as you can and have comments from me or Mr. Weebly accordingly. Thank you.
I appreciate, Chair Douglas, for the record, I appreciate the evolution the county has gone through. The county some 2 years back changed its stance and allowed for cannabis to be legal in the county and for licensing. But the county missed first sailing of the ship that allowed that regulation to come into play. And I think you're convoluting. I can't speak. We don't have a court decision with absolute certainty. But you are right, one license per county. However, there's a problem. They weren't under the regulation in the first request for licenses that went out. So we have no one who falls into that boat. This is a possible vehicle to extend that, but within the competing language of the law, it asks that we look at or allow for market study and analysis as to opening a new round of licensing. And that's an obstacle that hasn't been surmounted to date. Secondly, and most importantly, the licensing rounds are open to all who apply, not just to be requested by a county for one person. That's kind of problematic, as you may know from some of the statewide lawsuits that affected our predecessor in the cannabis industry in terms of fairness. But having said that, if other board members wish to weigh in, they can do so. If not, I have a motion that may go towards solving what's been brought before us today.
I have a couple questions. Member Durrett, for the record, Mr. Adler, you said that this limits it to White Pine County. How does it do that? Because it says that it seems like other counties could qualify for this. It seems like every year, every county could request more cultivation facilities.
A county can write a letter to the CCB in this simulated format here that would directly say this county wishes to have a licensing window for just the borders of our county. No other county can speak for another county, of course. So this would be a limited window, as in it can only stimulate a window for themselves. They can't stimulate a statewide licensing round. This won't trip it for Clark or anywhere else. If a county wishes to have continued activity in their county, they should have the ability to have continued licensing just as a county in this state, right? I mean, not even White Pine restrictively, I believe, but I do think the idea of cannabis licensing wasn't a one-time thing. It's a continual industry. It is a growth and a development of an industry. And there needs to be opportunities to have new licensing, not even to say have new participants, but there's people who approached me and said, I would love to move out of Reno. I'm getting charged rent 4 times what I should be charged because they know who I am. They know I'm a cannabis person. I own a building in Fernley. How come I can't just ask to apply for new licenses and have my licenses shift and changed over there? It is not possible today under the CCB. It is too restrictive in this licensing format today is the point. This stimulates a new way a county could request for themselves something, but you would have to work with your county or wherever you wish to do that to have any licensing window to open. But this is not for a licensee. It's not for a group, and it's not for an LLC. This is for a county. This petition was written for a county by a county and submitted by a county. So that the perception that this is for one company or the county's only doing it for one, they would like to see several. They would like to see as many as they could. Literally, the economic activity they could get out of this, all of it's good for them. That's where White Pine is at. I don't speak too heavily for them myself. But yeah.
I have 2 more questions
Okay.
that I think are for the AG's office. So how do we reconcile that shall language? The NRS says that they shall be issued a license in these local governments without one. Oh, yeah, I'm sorry.
Well, the shall language would require the CCB to open a new license round on such a request from any of the counties.
And that's an NRS, right?
Well, the shall means you have to do it. Yes.
Yeah.
Yeah. And just to comment on the change of location issue, the change of location is a statute, not a regulation. So that would need to be dealt with by the legislature.
So that means we are mandated.
If you adopt this regulation.
No, okay, so I'm not talking about the shall language under his, under the proposed petition or the proposed language. The shall under NRS, it says at least one medical cannabis cultivation facility.
I see where you're coming from. They would still have to apply, and they would still have to open a licensing round.
I think this is regardless of a licensing. Right?
No, that's not the case, because the statutes require any cannabis licensee to apply with the CCB for a license, which means you have to open a licensing round. As long as there's applicants, then you shall issue the medical license, not recreational or adult use, to at least one to a county, but they still got to apply.
And then I've a last question. So what are the plans or thoughts on the market demand studies that are a prerequisite to doing a licensing round?
Well, it's NRS 678A.310 directs the CAC, I think in consultation with the CCB, to conduct a marketing study to consider the distribution of the licenses across the state. The statute also seeks to have a marketing study as well, coordinated by the CAC. I'd also note that under 4.145 subsection E, the petition is required to have the petitioner identify all persons of group or groups who the petitioner believes will be affected by the adoption, amendment, or repeal of a regulation, including the cannabis industry as a whole. And, we did not see any marketing study or impact discussion regarding the industry as a whole in this petition. So I'll just mention that too, which I think kind of wraps into your marketing study question.
I don't remember the market study language. I know.
Yeah,
It's there.
No,
Well, and,
I know.
just briefly, we
what
we
is
were
it?
directed that the CCB would be doing their own market study and doing something on that line since October, right? For quite a while now. And then publicly it's been said for a while that the CCB as a whole would do that. And then just briefly, I heard on to my right a comment that I was supposed to submit a market study for the cannabis industry as a whole, as the whole of Nevada, with this petition to understand the change it would have for you guys. So a petitioner is required to also address how it will change the entirety of the state. Question mark?
Please, for the record, Chair Douglas,
Will
please
Adler.
understand, you are the petitioner. You brought this to us. We didn't bring it to you.
Okay.
You have an obligation to do certain things for the record or have it jointly done.
Will Adler for the record. I was just simply going off the direction we received. In our
Mr. Adler,
CCB.
you've been very
And then
pointed
Mr.
in
Weaver
terms of
does his hand
what
up.
the law has told us we have to do. And just our review of it indicates that you have a dual obligation, sometimes not completely having a full record of market study, but something that helps us move forward. This board is empowered only with the authority given to us by the legislature and the Nevada statutes. My motion at this time.
Mr.
Chair.
Weaver has had his hand up for quite a while, so I was gonna say.
This is Member Young. I have a question,
Go ahead.
maybe a follow-up question, if I may.
Yeah.
Again, this is Member Young, and this might be directed towards Mr. Adler or possibly Mr. Weevil from White Pine. What is the relationship with White Pine County and Silver Lion Farms?
White Pine County.
May I be heard? Can you guys hear me all right?
Yes.
Great, thank you. This is Mike Weeble for the record. I'm the county manager. And just for a little bit of background, I was also the elected district attorney here for 2 terms, and I've been on all sides of this issue from the very beginning. When this first came up under the initiative years ago, I was still prosecuting individuals for marijuana use in our county. So when these regulations were first imposed, we didn't know as a county how this was all going to end up, and coming to the table and having an opportunity to have some meaningful conversations. Yeah, that ship had sailed. And so, fast forward a few years, it's legal, it's thriving. The market is really important to the state. And, as this board is going to be addressing regulations, I think what Mr. Adler is trying to say, and what this petition actually is to have an opportunity to do some fine tuning to address some of these conflicts between the law and regulations. And this language would just allow White Pine County to petition to open it up for licensing. It's at that time, I believe, that a lot of the discussion on markets, and then this board still has ultimate ability to approve or decline those new applications. We're just looking to see how we can better our citizens' lives and make sure that we're part of this market and part of this industry, and not have a backseat to watching this economy pass us by. Just real quick, if anybody leaves Las Vegas or Washoe County or Douglas County, you see a lot of poverty still within the rural counties, because we have a one economy, we just don't have any diversification. Everyone knows this. I'm not saying anything new, but we grow and we bust with mining. And so we're trying to have some redundancies in the economy. And this supports the whole state. I mean, this supports the entire state, the health of our citizens. And we don't want to, and we're just trying to see how we can play a better role in working with the cannabis industries within the state. So to answer your question, Mr. Young, we don't have any, Silver Lines Farms is a private industry, and the best extent possible, as a board of county commissioners, as a county manager, we're trying to facilitate business and new economies in our county. And we brought this petition because we want to see them continue to develop into that industry, because of course it supports us with tax base, and that's the diversification economy that we're interested in. And it's not just for Silver Lines, as Mr. Adler said, but we're looking at other industries outside of marijuana as well, power industry. So I'm willing to answer any questions, and I'm sensitive to what you're saying, Chairman, about our obligations under this petition process, and we just want to be responsive. And if we need to provide more information about how changing the regulation, just making a little bit of a change in the regulations allow us to participate. If we need to do some market studies or provide any information, we'd be happy to do that. Of course, one of the other questions you asked, or someone asked on the board, was how can we limit this? You take some of the shall language out, the discretion is still on the board to approve those applications, and you can even limit it to the size of the counties. We could do, you can say, we do this across the Nevada revised statutes all the time. We can limit to counties with a population of less than 15,000 people or less than 20,000 people or whatever it is, so it doesn't open the floodgates to a bunch of these petitions. And that way the board still has control over that spigot, if you can say, the control of new markets, new entities coming in and trying to do this. So I appreciate the board's time today. This is a really interesting issue. And I know there's a little bit of conflict in there, and it's tough to say, well, that's the way the law was 10 years ago, or in this case, 6 years ago, and you can't participate now because we weren't willing to participate then, when we were still, revoking people's probation for using marijuana at the time. It was just a really tricky situation, and we're willing to participate, and I think doing it under the law and being compliant is the way to do it. And so I appreciate the board's time.
Thank you. Other remarks?
I just wanted to clarify that the market demand study language, I know that it's there. I couldn't remember when it's triggered, and it's as necessary. Thanks.
Part of, Chair Douglas, for the record, part of the issue before this board is we're not looking at something that just has county application. It has statewide application as well as to how it affects the marketplace. So I think we do need to do homework on this issue. I'm going to make a motion for denial at this time without prejudice, so that this matter may come back. Also asking our director to take this up with our advisory group and with the county in terms of pursuing the necessary studies to see whether or not it makes sense to open up additional licensing rounds. Again, understand the predicament. On the backside of this, any additional revenue that can be generated in the state goes in the education fund, which is a good thing that benefits your county and all the other counties in the state. So we just want to make sure that if this gets done, it gets done right. So at this time, that is my motion to deny without prejudice, so it be brought back. Asking the director to look with the advisory at possible study, working with the county.
Member Durrett, I second.
It's been moved and seconded. Any additional discussion? Hearing none by the board members. All in favor, please say aye.
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 Matter carries unanimous. Thank you. We'll see if we can get through these concerns. That moves us to item number 8, consideration for approval to extend February 5, 2022 final inspection deadline. Item A under that is Polaris Wellness Center.
Morning, Chair, members of the board. Steve Gilbert, Chief of Administration, for the record. I'm here today to present agenda item number 8, which consists of requests submitted by conditional licensees to extend to the February 5th, 2022 deadline to receive a final inspection by the CCB. The 2 requests in front of you today are both for distribution licenses. Unless the board has any questions or comments, I will begin going through each licensee's request. Agenda item A is for Polaris Wellness Center, LLC. On November 19th, 2021, Polaris, through its legal counsel, submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline for its distribution license T068. Specifically, Polaris requested an extension for 12 months after the current deadline. In the request, it refers to an event which took place during a routine inspection held at its cultivation facility in January of 2020. As a result of the inspection, Marijuana Enforcement Division staff quarantined a room at the facility which Polaris had intended to utilize to perfect its conditional distribution license. The investigation was concluded by the CCB in early 2021. Staff have communicated to Polaris that there are no areas of concern, and I'm available for any questions. And Lee McClure and Rusty Graff and Peter Ishak are present today to give a brief presentation and address any questions you may have.
Thank you. Mr. Graff.
Chair Douglas, member of the board, Rusty Graff, appearing with Mr. McHugh of Polaris Wellness LLC. We submit the application, and if the board has any questions, we're here to respond.
For the record, Chair Douglas, how are you resolving the issues that have slowed you down?
Your Honor, there was an issue as to violation that was approved via resolution in front of this board. The delay that was caused was the use of a specific room that was quarantined for an extended, I think Mr. Gilbert would agree, an extended period of time. I think it was over a year. So that's what caused us to not have this room available to conduct the transportation activities that we wanted to do.
The real question, what are you doing to go forward?
Your Honor, all we need to do is to get the license and to move forward. The room is free and available now. The materials that were in there have been removed pursuant to that agreement with the board.
Chair, this is Lee McHugh. In addition to that, it's been very difficult to actually get a vehicle. We've applied in a number of different places due to COVID and the supply chain. It's very difficult to get a transit vehicle right now. So that's part of the delays.
Other board members with questions or concerns? If there's no other questions or concerns, I would move for the granting of the request to extend the license to the appropriate date that we have been doing with other licenses for 1-year extension to February next year. And hopefully you'll get that done. That's my motion.
Member Grant, I second.
Been moved in second. Any additional discussion? Hearing none. All in favor, please say aye.
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 Member Young, are you approving, denying, abstaining? I didn't.
Could you not hear me?
No, I didn't.
Oh, I'm sorry. Aye.
Been approved unanimously. Thank you.
Sorry.
Thank you.
That moves us to item B, Green Mart of Nevada LLC.
Thank you, Chair. Agenda item B is for Green Mart Nevada, NLV LLC. On January 28th, 2022, Green Mart, through its legal counsel, submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline for its distribution license T038. Specifically, Green Mart requested an extension for 12 months to perfect its license. Green Mart reports it has faced some issues in regard to obtaining and or allocating sufficient space for the distributorship. Green Mart's prior plan did not allow for sufficient space for it to house distributionship within its cultivation and production facility. After having been awarded conditional retail dispensary licenses, litigation put those licenses at risk, and Green Mart was not sure if it would have the ability to perfect those licenses within the July 28th, 2020 settlement being reached. Green Mart is taking steps, including reconfiguring its space to allow it to operate a distributorship with the intent to transport to at least its own dispensaries. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Maggie McCletchie is present today to give a brief presentation and address any questions you may have as well.
On behalf of the applicant.
Chair Douglas, members of the board, David Figler, standing in for Ms. McCletchie. I'm sure you're disappointed to not see her and have to see my face, but it is my pleasure to make my first appearance before the CCB. In accordance with what Mr. Gilbert just indicated, Green Mart is taking steps forward now that that litigation, which we did not bring, is been resolved. The reconfiguring of those spaces specifically to be able to distribute to our own dispensary is underway, and we're asking for this one-year continuance as I understand is become somewhat industry standard. And if there are any questions, I am available to respond.
Thank you. Questions, concerns by the board? Hearing no questions or concerns, I would note for the record, Chair Douglas, the licensee needs to understand that they do need to, even with language out of the settlement agreement, to timely make application to extend licenses. We will, in this case, I would make a motion to approve, noting that if the 1 year to February of next year to do what they need to do. If not, they need to get for us timely, because if they don't, I would at that point be making a motion to deny in the future. So they need to make application and due diligence to do what they have to do in a timely fashion. So I would make. Do we have a second as to?
Member Durrett.
It's been moved and second. Any additional discussion? All in favor, please say aye.
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 Can you have him repeat the motion, please?
Chair, the court reporter is asking if you could repeat the motion, please.
The motion is for approval for 1 year, noting that if they are back in a year asking for an extension, it must be timely, otherwise it will be denied.
Thank you.
Motion passes unanimously.
Thank you.
That moves us to item number 9, approval and resolutions as to notice of final licensure, Silver Stage Wellness. Mr. Clements.
Thank you, Chair, and I'm happy to introduce Chief Gilbert to go through that one item for this.
Thank you, Director Calamis. Chair, members of the board, Steve Gilbert for the record. Agenda item 9A is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. We have one license to note today. Silver Sage Wellness LLC applied for an adult use cannabis distribution license during the May 2017 application period held by the Nevada Department of Taxation. On August 28, 2017, Silver Sage was issued a conditional license for an adult use distribution facility in the unincorporated Clark County jurisdiction. On March 15, 2021, CCB staff conducted a pre-opening audit and inspection of the facility. The inspection and audit results revealed some deficiencies that were not in compliance with the NCCR and NRS. A statement of deficiencies was issued on March 19, 2021. Silver Sage submitted a plan of correction, which was approved by the CCB on March 24, 2021. As a result, the CCB approved and issued final license to Silver Sage Wellness LLC on February 8, 2022. With that, Chair, members of the board, I'm happy to answer any questions.
Questions by board members? Hearing none. No action needs to be taken. It's just that moves us to item number 10, briefing to the board from our executive director.
Thank you, Chair. Just a couple quick updates on consumption lounges. We continue to sharpen the edges around the most recent draft. A lot of hours are being put into this from staff and the Attorney General's office. We certainly appreciate that. So we look forward to finalizing this. I keep threatening a workshop. We will have one soon. The goal here is to be as constructive as possible when we do have that workshop as we work to finalize these regulations. And so there'll be more to come on that hopefully soon. And secondly, Chair, you'd asked on the most recent demographic study that we sent out to registered agents. We sent that survey out to 16,000 registered agents. We had 7,000 surveys returned. We had about 70% response rate from owners, officers, and board members. These were both lower percentages than last year as far as response rates. We had about 50% last year, 42% this year. So for next year, which will result in a report to the legislature, we are going to look for ways to increase participation. One of those may be wrapping the demographic survey into your agent card application or renewal process. And so that is my report. If you have any questions, happy to answer.
Any questions by any board members? Misplaced page 2 of my agenda. Item 11, next meeting date is March 22nd, 2022. Item number 12, items for future agenda. I have one that I would not, sometime in the future, like our staff to take a look at application process. As of those people, 5% less the information provided. We are being inundated by LLCs and them telling us that somebody is publicly traded. Our amount is de minimis. I think we need to get more information as to who these individuals are, what they have, other stock interest, and so on. It's a global market now. It's not just a local. We would still be looking at waiving the 5% here. I would like to see us ask for a little more information, better vetted with the regulations the state has as to backgrounds of individuals who own interest in cannabis products. That's my request, that we begin to take a look at that. Don't want to make it any more cumbersome. We do need to know. Other board members have anything on their wish list that they'd like to look at besides trying to get a handle on our cannabis consumption lounges? Hearing none.
Great, we'll go to public comment. Is there anyone in Las Vegas wishing to provide public comment at this time? Please state your name for the record.
Thank you, members. My name is Dan Pabon, spelled Pabon. I am the general counsel for a company that does business as Schwaz out of Colorado. Schwaz entity is Medicine Man Technologies. Medicine Man Technologies is a creditor in a receivership case involving ACC Enterprises, LLC. Those licenses are C-130 and RC-130. And there was a motion that was filed in case number A21, A39, 350P on February 17th, 2022, indicating that the receiver, William A. Leonard, was recommending shutdown of that license facility based on its receivership status, inability, solvency issues, etc. My reading of the law, as it was put into AB 386, is that the Cannabis Compliance Board was to promulgate rules around the dissolution and winding down of assets as part of a receivership. My review of the current CCB rules, and I'm happy to be corrected, is that those rules have not yet been promulgated. And so if this issue comes before CCB, there may not be rules that govern this process and this system. So I guess my testimony or comment here is to maybe additional agenda items and or a contact with director or the staff to work with not just myself, any creditor involved in the case to understand what those receivership rules may be. So that's why I'm here today, to put that on the board's radar screen and to, I suppose, answer any questions if I was able. But I think I've come to the end looking at the regulations saying I don't think they exist, but I may be wrong.
This is a public comment period, so we're not able to dialogue with you as to that. Afterwards, you may want to see the director.
Thank you.
Great. Is there anyone else in Las Vegas wishing to provide public comment at this time? Okay, great. And as usual, any comment received written through email will be posted online at the conclusion of the meeting. Chair, back to you.
With that, I will make the motion for adjournment. Thank you very much. And